Our next case is Jabour versus Harms.
May it please the Court. I'm Steve Busey of Smith, Halsey & Busey in Jacksonville. I'm here on behalf of the appellant, J. Jabour, who is appealing before this Court and seeking the reversal of a judgment of the trial court voiding Mr. Jabour's election as a city councilman at large in the city of Jacksonville. The issue before the trial court was whether or not Mr. Jabour resided, that's the term used in the Jacksonville City Charter, resided in the district from which he was elected. He had a residence in District 13, which qualified him to serve as an at-large councilman for the entire county for Group 2. Mr. Jabour had two residences in Jacksonville. He had one in this district and one in another district. The law of the state says that people can have more than one residence. You can have more than one residence. That's Weiler versus Weiler, Minnick versus Minnick, Walker versus Harris, all cited in our briefs. But they go on to say you can only have one legal residence, one domicile. And the question of what is a legal residence or a domicile is where is your permanent abode, where do you return at the end of the day? And the trial court read residence as meaning legal residence or domicile. The charter doesn't say that. We think that was inappropriate. We think if you have a residence in an area, and he has had since 1998, and he spends a substantial amount of time there, he qualifies. Assuming for a minute that the trial court was correct in reading residence as being domicile or legal residence, we still think the trial court erred in two material respects. Two errors in failing to follow precedent of the Florida Supreme Court and of this court binding on that trial court. And those two errors justify reversal. Here are the errors. Well, Mr. Jabour has two residences. He decided in 2004, because he wanted to move his principal residence, his legal residence, his domicile, from San Jose to the beach, for the reason that he wanted ultimately to spend all of his time at the beach, and because he wanted the homestead exemption there and to save our taxes, homes tax cap, a 3% tax cap, because the beach's property was appreciating more rapidly than his other residence. So in 2004, he testified without contradiction. He formed the intent to make that his principal residence, his legal residence, his domicile, and he manifested that intent by overt acts. He changed his homestead exemption. He changed his driver's license. He changed his voter's registration. And he changed with the Department of Motor Vehicles where his vehicles are registered. He moved them all to the beach residence. So we had intent evidenced by overt acts. That's the rule of law. And it was in Ogden versus Ogden, which is a 1947 decision of the Florida Supreme Court, the court said the best proof of a person's residence or domicile is where he says it is. Intent coupled by overt acts. The best precedent you have in the briefs before you is Walker versus Harris. It's a fourth DCA opinion in 1981. And in that case, just like in this case, a successful city commission election was challenged by the unsuccessful candidate. And the issue was whether or not Mrs. Walker resided in the East Borough. She had lived in the West Borough with her mother, and she rented a room in the East Borough in order to qualify for the election. And she notified the post office, and she notified her bank that she was moving to the East Borough, admittedly for the purpose of the election. And the trial court judge disqualified her, said she wasn't qualified, that she had done that just for the purpose of the election, that it was a mail drop, and she didn't really reside there. That judgment was overturned by the Fourth District Court of Appeal in a panel decision which included Justice Anstead. And the judge said, they applied Ogden versus Ogden. They said the rule of law is it's intent coupled by overt acts. She formed the intent to reside there. She rented the apartment there. She notified the post office, and she notified her bank. The trial judge was concerned she didn't change her driver's license, and the Fourth DCA that didn't matter. That was overweighed by the other events. In this case, we have intent, 2 years before the election, for a different purpose than the election, to change the domicile to a place that Mr. Jabour had owned since 1998. He qualified there because he spent a substantial amount of time there. He met the legislative history of the purpose to reside because he knew the neighborhood. He knew what was going on out there. He had been there for 8 years. He was familiar with it. And he'd done what the Supreme Court in Walker said. There was another decision we cited in our brief, which was a trial court decision in Dozier, which in a comparable circumstance granted summary judgment in favor of the challenged successful election candidate. because they had established a residence in DeKalb County outside of Atlanta. That's where they live. He established a residence in another county for the purpose of qualifying to run for public commissioner, and changed his driver's license, changed his voter registration, and he was challenged on that, saying, well, he doesn't really live there. And the trial court said it doesn't matter where you spend the principal amount of time, it's what your intent is. The trial court said it's the intention of the person, not the percentage of time in any one location, which determines residency. What happened below was the trial court looked at the totality of the circumstances and found that Mr. Jabour spent during the qualifying period 54% of the nights in San Jose and 40-some-odd% of the nights at the Beach's residence. And by that quantification of where he spent the most number of nights and other comparable factors like that, said, well, that tells me you really live in San Jose and not at the beach. And that you had not changed your domicile because you had not abandoned your San Jose in 2004 and gone to the beach. That's the wrong rule of law. Ogden, Walker, all of these other cases we cited in our brief say it's intention manifested by overt act. Mr. Jabour declared his intention in 2004 and acted on it by all of the appropriate determinative criteria of residency. That is, his homestead exemption, his driver's license, his voter registration, where his cars are registered. And furthermore, the error in the trial court's decision is manifested by the Florida Supreme Court's decision in Bloomfield versus the city of St. Petersburg Beach. And in that case, a guy who was in Michigan was going to move to St. Petersburg, ran for the city council, established a residency in city council, moved in St. Petersburg, moved his wife there. But he stayed in Michigan to finish up his job there during the period of qualification where he's supposed to be in St. Petersburg. He did not physically remove himself to St. Petersburg, although he had declared his intent to be in St. Petersburg, and he has taken overt acts to be in St. Petersburg. The fact of the matter was he remained in Michigan. And that was the subject before the Supreme Court in Bloomfield versus City of St. Petersburg. And the Supreme Court held that he was a qualified candidate, that he had the intent, he had manifested the overt acts, and the fact that he wasn't physically in St. Petersburg during the bulk of the qualifying period didn't matter. The trial court's decision below runs directly counter to the Supreme Court's precedent in that case by saying, well, 54% of the time he was in San Jose. And so that was the first error, the failure to follow the rule of law of Ogden versus Ogden, Walker versus Harris, and Bloomfield versus the city of St. Petersburg Beach. The second error is that this court in Smith versus Crawford, following the Supreme Court in Irwin versus Collins, and notice the names in those decisions, said that when there is a doubt about the qualifications of a candidate, that doubt should be resolved, must be resolved is the language of those decisions, must be resolved in favor of the candidate for the reason that the court shouldn't be in the position of disenfranchising the voters. And in this case, this issue about residency was in the public record and in the newspapers before the election. 62% of the people in Duval County elected Mr. Jabour under those circumstances. If there's a doubt in the law about where his residence is, if there's a doubt, and anybody who look at this case can see there's a justiciable issue, fairly brought before the courts in good faith. But if there's a doubt, this court and the Supreme Court says it is to be resolved in favor of the candidate, not to disenfranchise the voters. And if you do not reverse the decision of the trial court, you're disenfranchising 62% of the people who elected Mr. Jabour to the countywide office in Jacksonville in May of 2007. We ask that you, based upon those rules of law that were not guided by the trial court, reverse the decision and direct the entry of judgment in favor of Mr. Jabour.
Thank you, sir. We'll reserve the balance of your time.
And please, the court, Neil Henriksen on behalf of the appellee, Robert Harms. Your Honors, after a 2-day trial before the court in which the court was able to evaluate the witnesses, the evidence, the inferences drawn therefrom, the court made a very careful finding. And the facts are not in dispute. There's no fact in this case that the appellant is saying somehow there wasn't substantial evidence of a particular fact. The issue in this case is that the court has found, one, in 2003, Mr. Jabour ran from the San Jose home. That's the home outside the district that was at issue in the 2007 race that the trial judge has overturned. In 2003, he ran qualifying from the San Jose address. He did not change any living patterns, the court found, in any way between the time of that election and 2007, and Mr. Jabour admitted to that. That was a significant finding by the trial court. He was unsuccessful in that race. The 2004 change of homestead, the court found, and it was undisputed, that in fact Mr. Jabour changed that only to obtain a tax advantage. Unlike Walker and the other cases, where the candidate said, I'm moving so I can qualify for this particular district run. The Dozer case, which was summary judgment, not after a 2-day intensive trial. In the Dozer case, that candidate, I moved to qualify to run. Mr. Jabour in 2004, although he changed no living patterns, he changed his homestead only to save money on his taxes. The change in the driver's license, the change in the voter registration, solely because he thought he needed to do it to change the homestead for tax purposes. In fact, the trial judge found in the record that Mr. Jabour had no present intention. And now this is where the important concurrence of the fact and intention comes into play. This trial judge found specifically no intention, no present intention to reside within the district for at-large 2. That is undisputed fact, no present intention. The law specifically required 183 consecutive days immediately preceding the qualification. And in this case, it was January 30th, 2007, the qualifying date, going back to August 1st. Jacksonville City Charter 5.04, 183 consecutive days immediately following. This candidate who ran had no qualification to run. Now, what did the trial judge do in terms of the law? He was very careful in his opinion. He looked at the city ordinance. He looked at the ordinance that enacted the qualifications for the city council residents. That ordinance said we want our city council representatives living for 183 consecutive days immediately preceding the election to get a feel for the community. That didn't happen. This is a candidate who ran in 2003 outside the district. Nothing had changed. Factual finding, not in dispute in this matter. And so we have a circumstance where a candidate who at one point qualified outside the district, changed nothing except for tax purposes his homestead, ran in 2007, and the judge applying the Jacksonville City Charter for 5.04, the qualifications, looking at how the city ordinance defined residence, which said where you sleep, it showed where your home is, took that, said, okay, now let me now move to what is your legal domicile, and applied Supreme Court, Florida Supreme Court precedent. The appellant acknowledges Bloomfield versus St. Petersburg, the city of St. Petersburg Beach, is operative. The court specifically said in this opinion, the Supreme Court said that you need a concurrence of both fact and intention to show legal residence. And in this case, there are extensive factual findings that there was absolutely no present intention. In fact, there's a specific finding that there might be a future intention. And in the record, and we've cited it, Mr. Jabour admitted there was a future intention, not a present intention. And again, this opinion is very carefully crafted because it is such a serious thing. But in fact, the point about, and the second point of error argued by counsel for the appellant, is a very critical one. essentially he's saying if this candidate was qualified in 2003, outside the district in which he's sought office in 2007, and nothing has changed. Well, their argument is that you don't have to have a legal residence to run in Jacksonville for the city council. And that's absolutely incorrect. It's inconsistent with the Jacksonville City Charter. It's inconsistent with Florida Supreme Court precedent looking at residence. The same case they heavily rely on, Walker, very specifically looked at the residence issue. Resided in, resident, language of that similar nature. It's cited to a Supreme Court case from 1926, Herron. The rule is well settled. Terms resident or reside in, the equivalent, is meant to be legal residence. The Jacksonville City Charter, the ordinance 1.102 defines residence. All these things are indications of the legislative intent to show that for someone to qualify for the Jacksonville City Council, they must reside in the district. And there is no dispute in the facts of this matter that Mr. Jabour did not reside in the at-large Group 2 district for the 183 consecutive days immediately before qualifying. With regard to the argument about the will of the voters, essentially that argument, if you reduce it down, would say if someone inappropriately or wrongfully qualified themselves for the election and they were elected in, well, that's fine. Well, that's contrary to law. It's contrary to common sense. If someone happens to improperly get on a ballot and the will of the voters at that point picks that candidate, that shouldn't be sanctioned. There's no public policy that could possibly sanction having a candidate who wrongfully qualified by giving incorrect information on a qualification form to then come in and, because they happen to win, and argue that the will of the voters is somehow being subverted. This is really where the rule of law comes into play and why the rule of law is so important in this case, why it's so important looking at how this trial judge, who sat through 2 days of testimony and looked at numerous exhibits, why he carefully crafted his opinion to deal with every avenue.
Counselor, so
yes.
under your view, then, a person with evenly dividing their time between 2 residences in 2 different districts in the city cannot qualify in either district to run for office, right?
That's correct, unless they manifested an intent, a specific intent, as Bloomfield recognized, to reside in a particular residence.
Well, let's just say that this person divided their time equally, exactly equally, between 2 residents, one at the beach and one in Mandarin. 2 different residences, 50-50. 1 week he's in the beach Monday through Wednesday. The next week he's in Mandarin the same amount of time, 50-50. Under your interpretation and the trial court's ruling, then, that person can never qualify for either district, right?
I respectfully disagree with the interpretation of the trial court, because what the trial judge was saying, you could qualify if you manifested the intent to reside in a particular location. And what the trial court found was Mr. Jabour had the intent to reside at the San Jose house.
I understand that, but in my hypothetical, this person lives 50-50 in 2 different residences.
Right.
Exactly 50-50. Since the trial court got into percentages and looked at the nights sleeping and that kind of thing, because obviously essentially it's a 60-40 finding here. So let's just say it's 50-50. Wouldn't you agree that under the trial court's ruling and your argument, that person can't qualify for either district seat, right?
No, not simply on that fact. No.
So he doesn't live anywhere.
Well, he would have to manifest an intent. He'd have to say, I reside in this residence, even if I sleep both places 50-50. He would have to, and that's what the court looked at. It didn't just say 60-40. That was an ancillary fact in this. It looked at 2003. He ran from the San Jose house. Nothing changed in his living habits. Nothing. The court specifically found a future intent, perhaps, to live at the Beach's condo, but a present intent. Nothing had changed. He had not manifested any specific change in his living pattern and the acts he took. There were no overt acts that demonstrated a change of legal domicile. And that's the standard here. It's a change of legal domicile. Because according to the appellant, you would be looking at where he resides. They say in 1998, when he bought the beach condo, he could have run from there. Well, in 2003, he ran from the San Jose house because he had an intent to reside there. So your 50-50 scenario is only part of the picture here. The real picture, and what the trial judge honed in on in a very careful opinion, was whether or not he had the intent to reside at the beach. And he didn't. He had perhaps a future intent, but his present intent, he had not manifested overt acts or shown an intention to reside anywhere other than the San Jose house.
But isn't living somewhere 40 to 50% of the time an overt act?
That's one piece of the
here,
equation.
Right. So here you have a person living somewhere 40% of the time. Their driver's license lists that as their address. Their homestead exemption lists that as their homestead. They say that's my residence. That's not enough in your view.
He's not saying it's his legal residence. So you could say, I could have 5 houses in Jacksonville, and I could call each one my residence. He is not manifest, and you have to go back to Bloomfield. Again, there has to be this concurrent. The Supreme Court has been clear. A concurrence of both fact and intention. And the trial judge was very careful about this. He was very cautious because he didn't want to trample on an election. He made that clear in his opinion. And when he goes through the facts, and when this court, there are no disputes on these facts. Specifically, in terms of intention, at page 5 of the opinion, he talks about page 5, that Mr. Jabour intends to live at the beach condo full-time one day. He does not wish to do so while his daughter remains in school. That's a fact that's not disputed. He had no present intention. And this is not peace. He's not like parsing, through. He's looked through all the facts. He's had a 2-day trial. He's looked at all the evidence. And the only reason, and the fact clearly undisputed, the only reason to move the homestead was to save money. It wasn't like in Dozer that they cite, like in Walker. It wasn't to run from that seat. Had he just said, I am moving in 2004 because I want to run for at-large Group 2. He never said that. That was not an issue in this case. The facts are he did it solely to save money. All the other facts demonstrate that this is an individual whose legal residence remained the same as in 2003 when he qualified to run for office within the district that is outside the district at issue in this case. The appellee asked that the very carefully thought out and really factually undisputed opinion of the trial judge be affirmed. Thank you, Your Honors.
All right, thank you.
Please, the court, respectfully, counsel for the appellee misstates the record, and I want to point to the record. There is no finding in the judgment that there's no present intent in 2004. There is no finding in the judgment that says that. To the contrary, here's what Mr. Jabour testified at trial, and this is in the transcript at 167, which is in Appendix 4. We decided that since that is going to be our principal residence, is our, from now on, is going to be the principal residence to switch our homestead exemption over to that in 2004. So he testified that in 2004, they made the decision that from now on, that's going to be our principal residence, and that's why they changed their homestead exemption. And to go to the judgment on page 4 is what the trial court says, notwithstanding these expressions of intention to change his residence from San Jose, notwithstanding these expressions of intention to change his residence, then the judge goes on and counts nights. There is no precedent before you that says you disregard intention and count the number of nights you spend where. That's contrary to Bloomfield, it's contrary to Ogden, it's contrary to Walker versus Harris. There's no precedent cited by the appellee that says that's the way you do it or that supports the trial court's decision. Notwithstanding these expressions of intention, I'm going to count the nights. That's what he says in his judgment. That's not the law. We have, and what happens, the difference between 2003, when he ran from District 5, and 2004, was what happened in 2004. He made the decision to change his residence. He made it for a valid reason. He wants to spend, and then what he said, the trial judge says on page 5, which I think was misquoted. Finally, Mr. Jabour testified that he and his family reside primarily at the San Jose house during the school year, and while he intends to live at the beach condominium full-time one day. Full-time is 100% of the time. And Mr. Jabour said that. One day, I intend to spend full-time there. But in 2004, he said that it's my principal residence. And that's where I'm going to have my homestead exemption, and that's where I'm going to have my driver's license, and that's where I'm going to vote. I'm going to have my voter's registration, and that's where I'm going to have my cars. And the binding precedent in this state is that's determinative. Intention plus overt acts, and these are the principal overt acts you look at residency. And it happened in 2004, 2 years before this election. It was error to disregard it, and it was error compounded that if you found there was even a question about it, that question should not be resolved in favor of the election of 62% of the people in Duval County that says we want this man in that office, and they should not be disenfranchised. Thank you.
All right, thank you, sir. Thank you both.